All right, good afternoon, everyone, and welcome to IPLSA's first online webinar, Easements and Pitfalls for Surveyors with Knud Hermansen. For those of you who don't know me, my name is Ariana, and I'm the Education Specialist with IPLSA. So I work very closely with both Laura and Kim on our education programs. So in the future, if you have any questions regarding our online webinars, you can feel free to direct them to me. I'm going to go ahead and type my email in the chat box on your taskbar so you have that for your convenience. Just a few other announcements. The handouts for this presentation are available in the handouts section of your taskbar. I will be emailing out the certificates next week to all of the attendees. If you know of anyone that couldn't make it to the webinar today or are interested in hearing, we will be selling a recorded version on our website, which will be available for purchase next week. All attendees have been muted to avoid audio feedback. So if you have a question, you can go ahead and type it in the question box, and Knud will answer them as we go. And with that, I will hand it over to him.
All right, well, good afternoon, and I'd like to thank the Society for inviting me to speak to you all about easements. A little background, I went to high school in Pennsylvania, graduated, went right into the United States Marine Corps, and they sent me to surveying school, and so I ended up spending 4 years surveying all over the world. I got out, went to college, got a associate degree, and I got a bachelor's degree in civil engineering, a master's from the University of Wisconsin in surveying and photogrammetry, my PhD in civil engineering with an emphasis on boundary law, and then I went on to law school. So I am a licensed surveyor in several states. I'm a professional engineer and also an attorney at law. I teach at the University of Maine in the Surveying Engineering Technology program. I also do a lot of consulting work, mostly in land titles, boundary disputes, and so on. I do a lot of alternate dispute resolution, litigation involving boundaries, and so on. I'd like to encourage you all, when you have a question that comes up, to go ahead and type it in. I'll try to answer them at the first available opportunity while I'm talking, while we're still on a certain topic. I also point out that at the very top of my notes there, you'll see my email address. If questions come up later, don't hesitate to send me an email. Well, I'm in phased retirement now, but I do teach at a public university, so I won't send you a bill if I do get a question. I do want to point out that I am not a licensed surveyor in your state, nor am I a professional engineer in your state, nor am I an attorney at law in your state. So just keep that in mind, that I'm not familiar with all the statutes and case law that applies to the state. All right, so let's talk about easements. I'm going to start with the basics because I don't know what level of listeners I have. I expect I have some very experienced surveyors out there that have surveyed as long as I have, and there's probably some that are just starting into surveying. An easement is a right to use the land of another. It's not an ownership. It's a property right in that the person, and we'll give you some terms right now, the dominant tenement is the person or property, in the case of an appurtenant easement, and I'll explain that in a little bit, that has the right to use the land of another person. The servient estate is the land that's burdened by the easement. Now, it's entirely possible for the servient estate to also use the easement. For example, if it's a common driveway that's being shared by two adjoining lots, they obviously have a right of way, which is, I won't say it's always synonymous with easement, but as far as we're going to talk right now, a right of way will be synonymous with an easement. So they each have a right of way in the property of the other, so they, in addition to use their own driveway also are allowing the neighbor to use part of their driveway as well. So just keep in mind, I'm going to be talking about dominant and servient tenement. The dominant is the one that has the right. The servient is the one that is burdened by the easement. Now, a couple other things, major definitions. Of course, you have public and private easements. The public easements would be typically the public roads, town, county, state roads. Recently, in many states, the state has, and even the municipalities have started to take roads in fee simple title for various reasons. However, you can almost be assured that the older roads, which would be most of the roads, are simply an easement. All right, so you have that definition, and there's some differences in easement law between a public road, public easement, and a private easement. Perhaps another important legal distinction is what's known as an appurtenant easement versus an easement in gross. All right, an appurtenant easement belongs to the property. Now, when I say that, it probably kind of rolls off your, off your thinking, and you say, okay, yeah, it belongs to the property, but the legal impact is quite serious. As we'll talk about, that the easement doesn't belong to the owner of the property. It belongs to the property, and that's such an important distinction. Let me just jump right in and tell you how important this distinction is. I want you to imagine that a person has an easement from a public road back to a piece of property, and let's call it 5 acres. So they have 5 acres and they have a piece of property, or an easement going back to that 5 acres. Now, that easement is appurtenant to the property. I'm going to say it several times because what I'm going to say next is just going to astound the heck out of many of you, and you're going to get flustered, but that's the law. So the person that has 5 acres decides they're going to add another acre to the back of their property. So they go to the neighbor and they buy the acre. And they come cruising up their easement. They go into their 5 acre piece. Now listen closely. The moment they cross into the 1 acre property, I don't care if they own that. They have no right to use the easement to get to that 1 acre piece of property, because the easement that's for the 1 acre property is appurtenant only to the 5 acre piece of property. Now, some of you, if you're following me, realize the implications of that, because I see this all the time. I've litigated the cases, and every time the judge has said, you don't have the right to go to that 1 acre, and the person said, but Your Honor, it abuts my 5 acre property. The tax maps don't even show the old boundary anymore. It's just one big 6 acre parcel. And the judge says it doesn't matter. The easement belongs to the property, not to you, to use it wherever you want to use it. All right. And that's the importance of the concept of an appurtenant easement. It belongs to the property. It doesn't belong to the owner of the property. All right. Now you could say, well, yeah, but if they own the property, they obviously own the easement. That's true. But they can only use the easement for the appurtenant property. They can't go and use it for anything else they want to use it. If they do so, it creates what's known as an overburdening of the easement. Now, I often see this happen because people will just add to their property and then use the easement. And let's be honest here, as you think about this, in 98% of the time, nobody's going to realize especially the servient tenement, is going to realize that that person that's using their easement is really trespassing on their property, because the person that's using the easement doesn't really trespass on the easement until they're off of the easement and have crossed into that 1 acre parcel. All right, so they just don't realize it. And so in most cases, they will get away with this trespass. And of course, if they get away long enough, then it gives rise to an easement by prescription that we'll talk about in a little bit. Now, the other thing, the other legal concept that's very important about an appurtenant easement. Oh, and before I get off that topic, let me just say that as a surveyor, you're usually the one that would pick up on this trespass, because you're the one that's looking at the boundaries and going back and realizing that the client's present property is composed of 2 properties that were put together in the past and so on. So you're the one that says, wait a minute, the easement is only appurtenant to the 1 property, not both of them. All right, the other concept that goes with an appurtenant easement is that once I have the appurtenant easement, and in the example I use, that would be a right-of-way back to this property. So once I've acquired that right-of-way, it becomes part of the property itself. Now, where this concept that I just told you about, where it becomes part of the property itself, it's appurtenant to the property and it's attached to the property, is that under the law, you don't have to mention it again. So if back in 1890, somebody, the servient tenement, conveyed an easement to the appurtenant property, the dominant tenement, and that dominant tenement never, ever mentioned it in the next, 140 some years, 20 some years, 30 some years, never mentioned that easement. They don't have to. It's attached to the property. It's conveyed with the property. Now, for the surveyor out there, what that means is you want to be very careful when you do your research, because a easement that was created like this example back in 1890 still is on the servient estate and is still benefiting the appurtenant property, even though it hasn't appeared in any property record since 1890. It's still a valid legal easement because it became attached to the property. And I like to think of it more as, if you buy a car or a truck, you don't have to mention that the steering wheel comes with the truck, or the 4 tires come with the truck, or the seat come with the truck. They're all part of the truck. And that's exactly how the law treats an easement that's appurtenant to property. Once it becomes attached to the property, it doesn't have to be mentioned to be conveyed with the property. All right. And by the way, one of the biggest sources of liability for the surveyor is easements. They don't find them, they don't locate them correctly, and so on, and then they're found liable. All right, so that is the big thing between appurtenant easements and easements and gross. Most easements are easements and gross because utility companies such as power companies and that, those easements aren't appurtenant to any piece of property. They're owned by a person, maybe a legal person like a corporation, but they're owned by a person. So most of the easements that you encounter in day-to-day practice are what's known as easements in gross. All right, so how are easements created? Well, most of you are probably familiar with the express easements, right, which are written into a deed I can go to a neighbor, they can convey me an easement. I can convey an easement if I own land to a power company or a gas line company or something like that. There's a deed. Probably not as common, but still common, would be as if if my client conveyed some frontage and then reserved to themselves an easement to access their remaining lands. And that's not in a separate deed, that's a reservation in a deed. So that's another common method. You also have covenants, which are often portrayed as what's called negative easements, and we're not going to deal with those too much. All right, so if you look at my handouts, I have 4 types of implied easements. All right, in Illinois, the subdivision and sale is actually considered an easement by estoppel. All right, so it would be in your state, it would be moved up underneath estoppel rather than an implied easement. Illinois recognizes 2 implied easements. One is an easement by necessity, which we'll explain in a little bit, and the other one is known as a quasi-easement. Right. So while we're on those 2, let's go down, and I've got some parameters for those easements. Now, a quasi-easement, let me just read the parameters I have there, and then let me give you an example so you can see how those easements, how you as a surveyor need to recognize a possible quasi-easement, also known as an implied easement. All right, so the use has to be existing at the time of the grant, and typically it's a division. All right, the use has to be apparent. The use has to have continued prior to the division and then continued after the division. And now the last part, necessary with strict necessity required for a reservation, that's not necessarily Illinois law, but that's a law that's often applied to it. So that 4th one, you could kind of draw a line through and not worry about it with your state. Now, let me give you an example of a good quasi-easement. I want you to imagine, and most of you have done this, the client calls you up, they've got, I don't know, 5 or 10 acres. Let's say there's an existing house on it, an old farmhouse, and they're going to cut that off and convey that because I grew up in an old farmhouse, and the last thing I want to do is live in another old farmhouse because, it was cold and drafty, but there's people that like old farmhouses. So this landowner finds one and he wants to dump the old farmhouse. So you go out there and you subdivide off the old farmhouse and convey it. Now, assume there was a septic field and the boundary went right through the septic field. All right. It's possible that even though the septic field was never mentioned as an easement, it may be an implied easement or a quasi-easement. First of all, let's go through these parameters for a quasi-easement. Was the septic field existing at the time of the grant or this one lot subdivision? And we'd say yes, it was. I mean, the old farmhouse there, it had the septic field, dumped the sewage out there, and it was there, and so it was existing at the time of the grant. Now, I'm going to skip over apparent because that might be a problem with some septic fields. But was the use continuous? So in other words, was the septic field being used by the farmhouse before the division? And then was it being used after the division? And I think unless they put in a new septic field, the answer would be yes. Now, the one I skipped over, was it apparent? Because a lot of septic fields aren't apparent, and therefore they may not be a quasi-easement. But if you had something like a mound or something obvious. Maybe the grass was, unreasonably green in a certain area or something like that. So it was apparent. Well, then we have a quasi-easement. So I've seen it used for septic fields a lot. I've also seen it used with power lines, right? Where you had let's say a power line coming into that old farmhouse, and the surveyor, the developer didn't pick up on the fact that overhead was a power line when they put the boundary in. So now this power line's cutting across the remaining lands. Well, I think in that case, it was apparent. Yes, maybe the person didn't look up, but it was apparent, was existing at the time of the grant, and was continuous. So keep in mind quasi-easements out there. A lot of times surveyors aren't aware of quasi-easements, and they think because the use has to have been there for X number of years for a prescriptive easement, and it wasn't, that therefore it can't be an easement. The question with a quasi-easement was it there before the division? Was it an existing use before the division? And if it was it used before the division, and was it used after, and was it apparent? And if so, then it was an easement. I don't care if the division occurred 10 minutes ago or 1 year ago. It doesn't matter. It's still an implied easement. All right, so the other implied easement recognized is what's known as an easement by necessity. Most surveyors, I say, are probably aware of an easement by necessity because they've come across what they consider landlocked property, because whoever conveyed property didn't, for whatever reason, remember to include an easement grant in that conveyance. But the law will imply an easement to the property. In other words, the law will not allow property to be landlocked. Now, that's not quite true, because the law will allow property to be landlocked, but in most cases it won't. All right. Now, I want you to think back on my scenario where we talked about the 5-acre property that had the appurtenant easement and the person that bought the 1 acre in the back. Can you see now, thinking about that scenario, that the 5-acre owner, who's completely unaware of the law regarding appurtenant easements, buys the 1 acre parcel thinking they're just going to add on to their property, maybe put a barn there, something else. It's a nice piece of property. And all of a sudden the survey and tenement says you can't use that easement to get to that 1 acre property. Well, it would appear they have a landlocked piece of property, even though it adjoins their property. And you think, well, I just won't wait. I'll just wait till the survey and tenement's not looking, and I'll just walk across the boundary. But that still doesn't provide legal access. Well, an easement by necessity provides legal access. So can you imagine going to the neighbor that you bought the 1 acre property from and saying, oh, by the way, when you conveyed that 1 acre piece to me, I also get an easement across your lands? Well, that neighbor's going to be very upset, because he's going to say, no, you use the easement that goes to your house. Why would you cross my land? And then you have to, somebody's going to have to explain to that neighbor that you can't use the appurtenant easement to get to the 1 acre piece, but it can't be landlocked, and therefore there's an easement by necessity across his remaining lands, right? So you can see how legally complicated it can quickly be if you aren't aware of the law regarding easements. All right, so let's look at the easement by necessity, the parameters for that. Now, this is important, that both of these are important. First one is it has to be reasonable necessity at the time of severance. And second, it has to be across the land of the grantors. Now, both of those seem, okay, you're looking at them and you're saying, okay, they seem rather straightforward. Well, the fact of it is, you know, I've been involved in litigation regarding both of them. Let me give you an example of truly landlocked property. All right, and this has occurred several times in my career. So we have a municipal road that's going back to this property. All right. And it's a woodlot property or farmland or, you know, brushy land, and it's, you know, it's been owned by somebody from away that doesn't live on the site. And the municipality decides they're going to discontinue the public road. And so they send out notices, and for whatever reason, the owner of this land doesn't think anything of it. And so they don't attend the meeting, don't say anything, and the municipality discontinues this public road. And 5 or 10 years later, after they retire, they go thinking they're going to go back to this property that they inherited or bought, and there's no longer a public road, and the old public road is now blocked by the servient, or what was the servient tenement. They don't want anybody going back this old public road, so they blocked it. And so this person that owns this land is looking at this and saying, but that's my access to my property. And the servient tenement saying, I'm sorry, but the municipality has discontinued the public road. It's no longer a public road, and I'm not letting anybody cross it. So they go see a lawyer, and the lawyer says, oh, don't worry, we got an easement by necessity. They don't. Litigated a couple of these cases, because look at that first one. For an easement by necessity, it must be a reasonable necessity at the time of the severance. Well, at the time this lot was created, there was a public road. So there was no reasonable necessity at that time. The necessity arose later when the public road was discontinued. So in every case, the court said, sorry, you've got a piece of landlocked property. And of course, the person's saying, how did this happen? And it happened because they didn't go to the municipality and say, you must pay me damages for landlocking my property. They just, for whatever reason, didn't do it. All right. So the second one there, cross the lands of the grantor. This has been a real problem for some of my clients, is because they've got this piece of property that for some reason they got or bought at a tax sale or something, and there's no legal access to it. But about 100 feet away on the neighbor's, across the neighbor's property is a public road. And they say, well, I'm going to get an easement by necessity across my neighbor's property to that public road. Maybe not, because it has to be across the lands of the grantor at the time the lot was created. And in a couple of cases, even though the public road's only about 200 feet away, they have to go a mile over a mountain down to the public road, because that is the lands of the grantor at the time of the severance. All right, so that's been a problem. It has to be across the lands of the grantor. It has to be across the lands of the person that created this problem with the necessity. The neighbor that's only 200 feet of land that you want to cross wasn't the reason that that person doesn't have an easement. All right. By the way, if you got any questions, go ahead and type them in. I can't believe nobody's got some questions now, but I guess maybe you're all listening intently. All right. Now, let's go back to here. And remember, I talked to you about where Illinois has subdivision and sale, but they call it an easement by estoppel. All right. Well, an easement by estoppel, by the way, you can have boundaries by estoppel and so on. if we look at the parameters required for estoppel, there has to be acts, declaration, and silence, which induces another in reasonable reliance to act or not act in a reasonable manner, such that the reliant party's rights are jeopardized. All right, so that, there it is. And so you wonder, okay, so how does this apply with an easement? If you can picture a subdivision plan, and if you're a surveyor out there, you've got lots of examples in your memory. And imagine an old subdivision plan where somebody's laid out lots and they've laid out roads in this subdivision, and it may even have occurred long before the current municipal standards for roads and acceptance of roads and so on. Well, under the theory of estoppel, if I create a subdivision plan and I sell a lot based upon that subdivision plan, in other words, in the description it says, lot 1 of, Hector subdivision or something like that, that incorporates the plan of subdivision into the conveyance. And here's the thing I want you to take away from what I'm saying. Every road shown on that subdivision becomes appurtenant to the parcel that was conveyed according to that plan. All right, so let me say that again. I know it, you say, well, okay, that makes sense, but you're going to see how critical that statement is. When I sell a lot according to a plan of subdivision, every road, and I want you to think of underlining the word every, and I mean every road shown on the subdivision becomes appurtenant to the lot. And it probably still hasn't sunk in. So now I want you to imagine a big subdivision plan, and you've got a client that has a lot right on the public road, right on the original public road, doesn't need any of the subdivision roads shown on the plan because their lot borders the existing public road. They didn't need a single one of those roads shown. Then I want you to imagine that in one of these roads in the back of the subdivision, as far away as you can get from the existing public road, was never opened as a public road. It was never opened. It was a paper street. Then I want you to think about a landowner or a lot owner next to this paper street that builds their garage into the paper street. All right, so now do we have a picture in our mind of what's happened? Here's the legal consequence. When they intruded into that back paper street, they trespassed on the easement belonging to the lot that fronts on the public road, because according to the law, every road shown on the plan is appurtenant to the lot. I don't care if he needs that road to get to work. I don't care if he even knows the road exists. The fact that the road is shown on the subdivision plan that was referred to in their deed means he has a private appurtenant easement in that road. So if his 9-year-old wanted to go back to that road, that's not a public road, and race up and down with his ATV, he has every right to do it. And therefore, the garage in that paper street is an encroachment on his private easement. So you see the danger? So when you're doing a lot survey and you say there are no apparent encroachments, did you look at every road within that subdivision? Because if there was any encroachment on any road in that subdivision, it's encroaching on that person's appurtenant easement. All right, so you see the danger of easements and why so many surveyors are found liable because they didn't understand easement law and how easements are located and what's appurtenant and what's not appurtenant. Now, again, let's be honest that if that situation occurs, and it occurs dozens of times across the United States, because I've seen enough of it myself, the fact of it is the lot owner that's along the public road never realizes they actually have an easement in that back road that's a paper street, and therefore they really don't care if some lot owner back there builds his garage into that paper street. They don't know, they don't care. However, just be wise that I've seen that have a very powerful play in a couple of cases, and it's caused some real problems. All right, so how does that fall under Illinois law with estoppel? Because the acts was the subdivision plan. The subdivision plan induced a buyer to buy according to that plan. A road shown on that plan is, without question, the buyer would believe that they can rely on the road shown on the plan, that they would be able to drive and use that road in reasonable reliance. All right, and they could use it in a reasonable manner. All right, and then to say you can't use it would be to jeopardize that reliant party's rights. And when we say reliant party, it doesn't necessarily have to be the only road that gets them to work. All right, now I should mention that I did look at some Illinois cases before this seminar, but obviously I didn't look at them all. But in many states, it's not just roads, because if there's parks or other things shown on that subdivision plan, there's also a pertinent easement in those roads. Now, having described this, let me just also point out what I see some surveyors have done, is they presume that we've got this subdivision, and the municipality came in at some later time and they opened up the streets and, you know, made them public roads, and everybody's happy and using that. And then some years later, the municipality decides, you know what, we don't need to maintain this road. None of the lots needed to access, so we're going to discontinue the public road. And so they go ahead and discontinue the public road. And of course, the people that own on both sides of that old discontinued road say, great, it's not a public road anymore, and we just got some more land for our lots. But just keep in mind that according to Illinois law, there's still that private appurtenant easement. So even though it was a public road, doesn't mean that there wasn't also a private easement. And because the public easement is gone from this corridor, doesn't mean that the private easement also disappeared. It didn't. So think of almost every road in a subdivision as having two easements on them. One's a private easement belonging to the lots in the subdivision, and the other easement is typically a public road easement. So when you remove the public road easement, the private easement still exists. All right. So again, I think you can see from what I've told you that there's an awful danger here, because I'm willing to bet that most surveyors that think, well, the municipality discontinued the public road in the subdivision, I don't need to worry about it, it's gone. No, there's still that private appurtenant easement that was created when a lot was sold with reference to that subdivision plan. All right, easement by prescription. Basically, I guess the easy way to remember an easement by prescription is think of a adverse possession, where you gain title by possession. Well, you can also gain an easement, not by possession, but by use, by adverse use. So if you have a use, not possession, a use now, a use that has occurred for the statutory period of time that was uninterrupted, open and notorious, actual use, hostile use, exclusive use, and so on, just like adverse possession, the user gains a prescriptive easement. All right, the user gains a prescriptive easement. All right. Now, I just want to tie this back with a quasi-easement, because I've had to litigate some cases where there's was this use and the use was blocked and so on. And I prefer to argue a quasi-easement if the facts support a quasi-easement, because a quasi-easement has broader use than a prescriptive easement. A prescriptive easement can only be used in the manner it was used for during the prescriptive period. The width of a prescriptive easement is only the width that was used during the prescriptive period, while a quasi-easement may not have a specified use, but the use or the width of a quasi-easement is reasonable, versus a prescriptive easement, which is what was used during the prescriptive period. So sometimes it certainly pays to argue for one easement over another easement. All right. I don't see any questions. So if somebody sent me questions, I'm not getting them. All right, just
Dude, I just want to interject for a second. We have had a few questions just pop up in the last few minutes. If you're not seeing them, I'd be happy to read them for you.
Yeah, I'm not seeing them, so go ahead and read them for me. Okay.
I'll start with the first one. Can you draw a diagram to go over what was explained? This was around 136, just a few minutes ago. Maybe if we could get some more information from the question asker on that one. We could move on to another one.
Yeah, better so, because I'm not sure what I was doing at 136.
I totally get it. Okay, so here's one. So are you indicating that when a row is established, I'll just use the acronym, when an ROW is established by a SUB and then a municipality wants to vacate it, technically you should have every subdivision owner vacate the ROW also? Their private rights there too?
Yes. That's correct. So when a right-of-way, the ROW, when the right-of-way was created by the sale of a lot with reference to the plan, that's when that right-of-way was created, by that sale of a lot with reference to the plan. In order to get rid of that private easement, they have to go to the lot owner and have them sign off on it. Now, that doesn't, here's the kicker, all right? Nowadays, a typical subdivision, you don't sell a lot until the municipality has approved the subdivision plan and accepted the roads. So in that case, somebody buying a lot doesn't necessarily get a private easement, because when they bought the lot according to the plan of subdivisions, they weren't being guaranteed a private right-of-way, they were being guaranteed a public easement because the municipality had already accepted the plans. So a lot of the law I'm talking about tends to apply to the old subdivisions where lots were sold, and then sometime later the municipality didn't have to accept the plan. It was just one of those things. They, you know, a developer went and laid off the lots and sold lots, and then later the municipality decided they're going to open public roads. All right, what other questions do you have?
All right, we've got one more. A person conveys an easement across a parcel that he thought he owned by means of an executor's deed. It's discovered the X deed is invalid. Is the easement conveyed to other for their benefit still valid?
No. No, if the surveying estate didn't have title when they conveyed an easement, then the easement that was the apparent easement that was conveyed, there was no title to that. All right. Now, in that case, though, if it's used long enough, we might have a good case for a prescriptive easement. And there's some other, I won't say there's no chance, because there's some other legal theories that could come into play, certain estoppels and so on, that might allow that conveyance to actually be recognized. But as a general rule, if the surveying estate doesn't have title, they can't convey any rights in the title that they don't own.
All right, looks like we've gotten one more just in the time that you were answering that one. Can you describe a situation where the municipality vacated a street ROW and an owner later, perhaps years later, tried to make a claim to the easement that was created by the plat?
Yes. The situation that I'm aware of is that the utility company went in when this was still a public road, and they buried their utility lines. You know, it could be electric lines, could be sewer, could be water, whatever, but they buried it in that public road, which was a public road at the time. And the reason they had the authority to do so was because it was a public road. And later, the municipality vacated the road, but because the utilities were buried, the municipality didn't realize, so even though there wasn't any vehicle travel on that old road anymore, that there were still buried utilities down there. And so when they discontinued the public easement, there were still lot owners that needed that utility for electricity or sewer or whatever. And so when the lot owner that was along the discontinued public road started to build a garage across it, that's when it was discovered that there's buried electric lines that still supported the subdivision, and you saw a lot of litigation. And it was finally recognized that as long as that electricity line served the lots in that subdivision, that they were doing so as part of a private easement, and you know, that was the law. The other thing I've seen it happen is that it tends to stop development. So landowners or lot owners that don't like development occurring in the back will often use that and quite successfully to prevent development in the back, because the developer wants to take the old unsold lots and reconfigure the subdivision plan and eliminate roads in one spot and put them in another spot, and they can't because of that, those private easements. So I've seen that happen a couple times. All right, so do we get some clarification on that?
I think that, okay, so we've got one more question coming in, and then it looks like they're slowing down.
Okay.
Someone also answered yes, so it looks like you did get clarification. But I'll read off the last one here. Does a re-subdivision with its own easements extinguish old easements from the original subdivision?
Yeah, see, that's certainly possible, provided there was no lot sold based on the old subdivision plan, because the private easements that arose based on the fact that a lot owner purchased their lot with reference to that subdivision plan. So if the developer hadn't sold any lots, then there's no estoppel, and they can go ahead and reconfigure their subdivision. But once they've sold one lot according to the old plan, then they have to get the lot owner to sign away their rights in these roads that were created. And where I see the problem is a lot of times the developer goes back to the municipality and says, I have a replat of the subdivision, and the municipality says, yep, okay, that's fine, we'll allow that. But that municipality is not factoring in that that private rights have now accrued, because the municipality is not interested in private rights, they're interested in the public rights. So so that point gets missed. So it is a real problem, and I've seen that problem come up and prevent the replat of a subdivision. Any other questions?
Doesn't look like we have any more at this time.
Okay, well, that's good, because I was getting worried here when I wasn't getting any questions. I was thinking, man, I am doing such a fantastic job. I've never done such a good job, but now all right. So we've gone through several ways to create easements. Just to sort of wrap that up, you have some common law easements like navigable waters and drainage and lateral support. You also have condemnation, dedication, and so on as a way to create easements. And I'm not going to get into those. Condemnation's rather straightforward and so on. Now let's talk about extinguishment of easements. All right, one of the things I want to mention is that private appurtenant easements are almost never extinguished by simply abandonment. When I say abandonment, they haven't been used. They haven't been used for decades, maybe centuries. That easement hasn't been used. It's still not abandoned. In order to have abandonment of a private easement, either the servient tenement or the dominant tenement has to block the easement in a permanent way. All right, not just with a gate, but has to, dig a ditch across it. You see, if God or Mother Nature allows big trees to grow in the easement, that doesn't do it, because that's not an affirmative act by a person. So either the dominant estate, I've seen the dominant estate do that because they mistakenly build a house that blocks their own old easement. They had another way in and they blocked the old one by building a house, or it could be the servient tenement just blocks the easement. Let me just say, I'll give you a real life case here. Back before I became an attorney, I've been a surveyor for close to 50 years now. And I worked for a forestry company for many years, and the boss asked me to look at surveying his office property, and I did that, and I found out that he had built his office right across a easement that was accessing the farmer's field in the back. Now, the farmer had other ways into his property, and for all I know, didn't even know about the easement that he had, that my boss's office was blocking, right? So I had to go to my boss and say, boss, I have some bad news and good news. He says, well, what's the bad news? I said, you built your office right on somebody's easement. And he says, oh, no. He says, what's the good news? I said, the good news is you built your office right on somebody's easement, and the office has been there for 20 years. And he says, well, what's that mean? And I says, that means that there's been abandonment by clear manifestation. In other words, you blocked, as a servient tenement, you blocked the dominant estate's easement, but you have done so long enough that they've lost the easement. So that, that was the bad news, good news kind of deal. But you can have abandonment. You can have the municipality actually condemn the easement and take it away. We talked about discontinued, where a municipality can say we're no longer want a public easement, and they discontinue it. You can have the dominant estate or tenement give a deed back to the servient tenement, which releases the easement. One of the things I recommend on new subdivision plans is you have an express condition. And what I like to do when I do a subdivision plan is I put on that any easement shown on this plan that is not used within a 5-year period is extinguished. Because, you know, you have a lot of easements that just don't get used for decades, and they're still there, as I said. But if you have this condition, that means if somebody doesn't use it within that 5 years, and I'm not recommending 5 years, you can make it 10 years, 20 years, whatever you want. But at some point, if they don't use it, or they used it and then stop using it for a length of time, it's gone. Foreclosure. Foreclosure is a way. Now, I want you to think about this. If I own a piece of land and I have a mortgage on it, all right, so let's say I own a farm and I have it mortgaged, and I sell the power company an easement across my property. And after I do that, the bank forecloses on my property. They get the property after they foreclosed on the property. They get the property in the same condition it existed when the mortgage was executed. So in other words, they get the property without the easement. And so you have the situation where there's an easement on record for the power company, but because they didn't get the bank to sign off on the easement, that easement is now a trespass on the property. Even though it was signed by the parent landowner at the time, it's recorded and everything, that easement disappeared as a result of foreclosure. All right, forfeiture for misuser. That's where if you misuse the easement long enough, the judge is going to say you lost it. You know, it's kind of like your child when they use, you know, the 16-year-old that you have at home, when you let them use the car and you see them letting a friend drive the car, they lose it. Think of an easement like that. They forfeited for misuse. Non-use, I have for paper streets. It's also, like I say, non-use generally doesn't extinguish a private easement. It's possible for non-use to extinguish a public easement, but it can extinguish a private easement. For example, if somebody's established a prescriptive easement and it's not a matter of record, they've just used it long enough, and then they stop using it for a long time such that there's really no indication that they ever used it, it must be stated they probably lost what they had once gained by prescription through a long period of non-use. Public roads are often found to be abandoned by non-use, and that usually occurs when the public comes in and they straighten a road, and so there's this old dangerous bend in the road, and they come in, they condemn a strip, and they build a new road, but they never took care of the old road. When they open up the new road, many courts decide that they have indeed abandoned the old road by non-use and abandonment. Part destroyed, that's if you have like a common wall in a condominium and the condominium burns, then the easement's gone. We talked about reverse prescription. That's what happened with my boss and blocking that easement and so on. Listen, I see that it is 3 o'clock, and I know that everybody listening to this probably needs to get back to work. So I am going to stop and say thank you very much for the invitation. I appreciate the questions, and we'll talk to you.
All right. If you have time, we have one more question.
Oh, sure. I always got time. Sure. Go ahead.
Okay, so here we go. A 50-foot public right-of-way is dedicated. A 10-foot wide public utility easement adjoins the right-of-way. In the future, the road right-of-way is widened to encompass all of the 10-foot utility easement. If later the entire dedicated and widened road is vacated, does the 10-foot utility easement still remain?
Yes. You don't often hear
All right.
attorneys being that confident, but I'm pretty confident. Yes. All right.
Okay, so that concludes our program today. If anyone else has any further questions, you guys can feel free to email me. As a reminder, I'll go ahead and send an email to all of the attendees today with PDH certificate before the end of next week. If you guys had trouble finding the handouts, they are under the handouts section of your task bar. They should be underneath the questions box. If you still can't find them, send me an email. I'll be happy to attach them. I just want to say thank you, Knud, for showing up today. I know a lot of our members really appreciate it, and they were really excited to have you, and we are as well. So thank you for a great presentation, and I hope everyone has a good weekend.
All right, bye now.